well. Although MWL is headquartered in Wisconsin, we are a national subrogation firm. We handle subrogation in all 50 states, but particularly we are proud to announce that MWL has just opened an office in Austin, Texas. I was happy to help them open this branch. I'm certainly enjoying the weather and looking forward to our growing future in Texas with all you. This presentation is just going to be giving a broad overview on the aspects that I deal with and that you will be dealing with Texas auto subrogation in Texas. Unfortunately, Texas can sometimes be the forgotten art in the legal field, but as many of you here know, nobody can deny auto subro's importance. 263 million cars drive around the United States. 6 million accidents happen annually. $70 billion in auto bodily injury claims, and another $40 billion in auto property claims. I stress these numbers because there's a lot of potential here in auto subrogation, and the many I've spoke to, there's a lot of money being left on the table. A lot of people not pursuing these third-party subro claims. And a lot of the time, that's because these auto subrogation claims involve smaller files that may not seem to be worth your while. It makes it tough to get involved, to travel, and to come out ahead on these ones. But that's really the goal of today. I want to give you the tools, the knowledge, to be able to go out there and make recoveries on your own. It's not always have to get legal counsel involved, just to know the kind of tactics that you may run into. I'll be walking through the most common legal issues that I'm personally confronted with, and that you will certainly run into as you run head on into trial lawyers who try to get you off your subrogated right. Real quick, I wanted to announce that this webinar is pre-approved for Texas CE credits in order to satisfy the Texas Department of Insurance. We're required to prove that one. You were in attendance today, and more importantly, that you were paying attention today. So for those of you who want to receive this CE credit, at some point in today's webinar, Jamie Breen, who's helping out in the background, like I mentioned, will be sending you a chat message, just kind of asking if you would like the credit. All you need to do is simply type yes, hit enter, and no need to worry that that chat message doesn't expire. And if you're not interested in receiving credit, just ignore it. All right, let's move on. The state of subrogation in Texas. Texas is a fairly good subrogation state. It's also a rather large state, as you both know, both population-wise and square mileage. There's around 24 million people that live in Texas, and it has the most roads out of any state in the United States. It's got nearly 700,000 miles worth of roads. And just to stress how much that is, in second place is California, which only has 400,000 miles worth of roads. Now, as the PowerPoint states here, it's got 17 million licensed drivers. Unfortunately, Texas is also home to one of the highest rates for uninsured drivers. This is listed, we've got listed 14.1% uninsured. I've seen websites estimate that it can be even as high as 1/4 of drivers. So the UIM is something particularly to pay attention to, as you'll run into that a lot here in Texas. Just a quick overview of Texas auto subrogation. Again, we'll be going through this in more detail throughout the presentation. Texas recognizes both an equitable and contractual right to subrogation. It's also a very favorable state for MedPay subrogation. It's one of the states that's an add-on PIP state. This quickly means that PIP cannot be subrogated, but it also means that it does not hurt us on the tort side of things. So we have the full ability to pursue any and all subrogation via the courts. In Texas, you also have a right to reimbursement if it's provided for in the policy. And you are also able to contract around the made-whole doctrine. I've got quite a hefty slide on the made-whole doctrine that we'll go into in quite some detail. So stay tuned for that one. And like I mentioned, Texas is big. Not the largest state, but it's got 254 counties. Most of these counties are fairly plaintiff-friendly, but due to its size, it can make subrogation tough, especially if you're on one side of the state and you have a small claim on the other side. It's going to be hard to travel over there for some of these smaller files. It takes 13 hours and 1 minute to drive from Orange, Texas on the East Coast all the way to El Paso, Texas on the West Coast. But overall, you're not going to have any migraines figuring out your rights here for auto subrogation in Texas. There's much more difficult states out there. Michigan, New Jersey, New York are some of the usual suspects. So moving on, it's tough to talk about auto subrogation generally without discussing the specific types of auto insurance that are available. Some of these are mandatory, some are optional. I'll be quickly rolling through these and informing you which ones are and aren't. The first one, of course, is auto liability insurance. Most people here should be pretty familiar with this. Auto liability insurance is required in Texas. This pays for any damages to person or property of the victim of an accident for which the covered insured is responsible. It pays only up to the policy limits that are listed in the policy, and we'll go into policy limits later on. But auto liability coverage will pay for medical and funeral costs. It will cover lost wages, pain and suffering, reasonable car repair, as well as damage to other property. You can also recover for rental car and loss of use. This is true in Texas even if you haven't rented a substitute vehicle, but we also have a slide on loss of use later on. Also covers punitive damages. As I mentioned, Texas auto liability limits. Texas limits for personal auto are $30,000 per person, $60,000 per occurrence, and $25,000 for property damage. There are also different limits set for commercial trucking. This is set by federal law, and it really depends on the type and size of the truck in question. The limits are set by federal law for interstate transport, and then also Texas law for intrastate transport. As you can see, I listed some of the different weights and models there with the different limits. There's also a different set of limits for interstate transportation of passengers. This is something that's commercial bus lines is what we're thinking of here. But generally, these limits are based on how many passengers specific commercial lines are carrying. But as the PowerPoint notes here, this does not cover school buses. School buses are covered by something different. But state and federal law state that the motor carrier must always have proof of the minimum level of insurance. The proof can be shown in a number of different ways. My colleague Ashton Kirsch is one of the most knowledgeable people I know on this topic. MCS 90 endorsements. You've got the Form F endorsement for interstate commerce, MCS 90B for carrying of passengers. This stuff really starts going down more into the realm of transportation law, which is a different topic that I think Ashton does cover, and it's really fascinating. But suffice to say, motor carriers are required to have higher limits, and their insurance carriers may have an obligation to pay even if that coverage is denied. There's for public policy reasons. PIP, or also known as a personal injury protection. This is also required in Texas. However, it can be waived by the insured in writing. The agent is required to provide a form in which the insured can reject this type of coverage. So it must be offered, but can be rejected. PIP is a no-fault type of coverage. This is similar to the no-fault that you see in New York, New Jersey, Michigan. PIP covers the medical and funeral bills for the insured's family, and any passengers in the vehicle at the time of the accident. Um, it must be offered in at least $2,500 and covers things such as the medical expenses, 80% of lost wages, and the cost of a caregiver. However, like I mentioned earlier on in the presentation, Texas is an add-on PIP state, which meant that PIP is optional and does not influence tort claims. This is where Texas is a little different than those other no-fault states, New York, New Jersey, Michigan. PIP coverage there in Michigan and New Jersey, New York, those will operate to limit or negate a third-party tort claim brought by the injured party, but not so in Texas because you're able to, because it's optional. PIP coverage essentially is the same thing as MedPay, except that MedPay does not include coverage for the 80% of lost wages. What this ends up meaning is that usually PIP is the better buy over MedPay. However, it may change based on the person to person, depending on what the insured has for medical coverage, but typically you don't see one person that has both MedPay and PIP. Similar to PIP, we've got UM and UIM coverage, and remember this is one I mentioned you should pay attention to in particular, given the amount of uninsured drivers in Texas. Like PIP, UM/UIM coverage must be offered by the insurer, but can be rejected in writing through the signing of a waiver. UM/UIM coverage pays for any expenses arising from an accident due to lack of insurance or inadequate insurance on the part of the negligent tortfeasor who caused the accident or injury. It's got the same minimum limits as the liability limits, the 30, 60, 25, if you remember previously. However, these can be in any amount, but are limited and cannot be more than the liability limits that are stated in the policy. Further, the bodily injury portion of UM/UIM, it pays with no deductible for past and future medical bills, for lost wages, loss of earning capacity, physical pain, mental anguish, disfigurement, and permanent or partial disability. Essentially, UM/UIM coverage is acting as the liability insurance of the tortfeasor, since they don't have any or don't have enough. The property damage portion of UM/UIM pays for the repair to the insured's vehicle if the cost of the repairs does not exceed the fair market value. This also can pay for damage to items within the car, damage caused by the insured to other property, not due to the negligence of your insured. So this is in instances where your insured is caused to drive off the road by a negligent third party and runs into a municipality's light poles or a house. The UM/UIM property damage portion also can cover rental car expenses. The deductible on property damage portion of UM/UIM is set by statute at $250 per occurrence. And this covers the insured's family, and any passengers in the car at the time. Typically, you see the same UM/UIM policy terms, and I'm just going to go ahead and read this. We will pay damages which a covered person is legally entitled to recover from the owner or operator of an insured vehicle because of bodily injury sustained by a covered person or property damage caused by an accident. The key here to recovering under UM/UIM is that the insured's injury or damages must arise out of the ownership, the maintenance, or the use of the covered vehicle. And I stress here, arising out of the use. This, it might seem plain, but this refers to the use of an automobile as an automobile. The reason I stress this is because there's been some litigation recently kind of fleshing out this more obscure issue. The question has come up if such intentional acts create liability arising out of ownership, maintenance, or use of a vehicle. The great example of this is a drive-by shooting. I mean, it's an act that arise out of the use of a vehicle, but it's an intentional act. In the case of a drive-by shooting, courts have found that the incident did not arise out of the ownership, maintenance, or use of the vehicle. However, kind of interesting towing this line is when there's an act or injury that are integral parts of the use of a vehicle, it's generally held that it does arise out of the use of a vehicle. Interesting case was an injury was caused while driving. The injured party accidentally shot off his gun while driving his car. The court did hold that this arose out of the use of the guy's vehicle, and the loss was covered. MedPay coverage in Texas, this is totally optional. Medical payments coverage will pay for medical and funeral bills resulting from accidents, including those in which the victim is a pedestrian or a bicyclist. MedPay in Texas, this covers, again, it covers the insured's family, and passengers in the car at the time of the accident. And this is, like I said, it's no fault. This is regardless of who is ultimately responsible for the accident. Also, like I mentioned, MedPay is similar to PIP. MedPay is a little cheaper, but PIP sometimes ends up being the better deal since it does cover that 80% of lost wages. As I mentioned, you typically see one, but not both, of MedPay or PIP. MedPay coverage can be in any amount. Typically, it's found in amounts of $500, $1,000, or $2,000 being the most typical amounts. Collision and comprehensive coverages. These are the standard type of coverages that we typically deal with when handling auto property subrogation claims. Collision. Collision covers damages to the insured's vehicle from colliding with another vehicle. This type of coverage pays the cost of repairing or replacing a car after a collision, regardless of who was driving or who was at fault. The total payment is limited to the actual cash value of the vehicle minus the deductible. Actual cash value minus the deductible. Actual cash value meaning that it's simply just the market value before the car was damaged. You may also hear this referred to as book value, but sometimes that can be a contention point in subrogating these claims. In contrast, you have the comprehensive coverage. Comprehensive coverage covers damage to the insured's vehicle when it's caused by a catastrophe other than a vehicle collision. These are instances in which theft, fire, vandalism, hail is a good example. Comprehensive coverage will also pay the cost of a rental car if the insured's vehicle is stolen. However, in cases of auto theft, typically the insured is required to promptly report the theft to the insurer. Otherwise, they may not qualify for this kind of reimbursement under comprehensive coverage. But comprehensive coverage, like collision, is limited to the insured's vehicle's actual cash value or book value minus deductible, or it can be the reasonable cost of repair, either or. So now that we covered our bases, kind of talking roughly about the different coverages, I wanted to move on and discuss how we actually go about subrogating these things, the meat of why we're here. I like to start with the easiest one, PIP. PIP is real simple. Section 1952.155 states simply that there is no subrogation allowed for PIP in Texas. Pretty simple. There is an exception. Subrogating, you can subrogate for PIP if subrogating against an uninsured motorist. And like I said, this is rather common in Texas. There are a lot of uninsured motorists here. So although you're not allowed to subrogate PIP in Texas, it's a good one to remember because it does come up quite often with 1/4 of drivers not being insured in Texas. UIM subrogation, we look to section 1952.108. This gives the insurers some subrogation rights against an uninsured or underinsured motorist. However, UM/UIM subrogation, as likely many of you know, it's like squeezing blood from a turnip. Not a lot of fun. These can be really difficult cases to come out ahead on. They can deal with low dollar amounts. You're going against a guy with no assets, really not worth your time. And typically these cases get into the area of debt collection. Here at MWL, we're not set up appropriately to handle these kind of debt collection cases. However, I do have a lot of clients asking me to go after and obtain a default judgment against an uninsured motorist. And we do this for a flat fee. And we will obtain the default judgment and then turn it back over to the client, the insurance carrier, who will then give it to their own in-house debt collecting division. So that can be an interesting way to approach these files and try to get some recovery where typically most would shy away from. Continuing on with UM/UIM subrogation, there are rules in Texas which require a consent to settle and a consent to sue from the insurer. The consent to settle clause comes from the standard Texas personal auto policy, which provides that a carrier does not provide coverage if the insured settles a claim without the UM/UIM carrier's consent. Typically, there's a 30-day deadline here to get the carrier's consent. But as we saw, we do have a right of subrogation here, but if the insured runs out and quickly settles this for $500, signs a release for any and all claims for the uninsured motorist, it happens a lot. A carrier's subrogation claim could be barred. Texas courts have approved policies with provisions that exclude coverage based on these types of settlements without consent. However, the Texas Supreme Court held that a carrier may only escape liability due to a settlement without consent only when the insurer is actually prejudiced by the insured settlement with the tortfeasor. So the only way you can escape is with actual prejudice based on the settlement. Furthermore, if the UM/UIM carrier unconditionally denies coverage, if you deny coverage of this UM/UIM policy, carrier waives its right to consent to settlement. This kind of opens up the floodgates and allows the insured to go out and settle on his own. So something interesting to keep in mind. There's also the consent to sue clause, which I apologize, I don't have a slide in here, but it is rather similar to the consent to settle. The consent to sue is related clause. It's also found in the Texas auto policy, standard auto policy, and provides that the insured must obtain the carrier's consent in order to bring suit. Like I said, very similar to consent to settle. An insurer's knowledge that the insured has filed suit against an adverse motorist does not satisfy this requirement. You do need written knowledge. Or written consent, I'm sorry. An insured with UM/UIM coverage is typically confronted with three choices when coming up to sue. The insured may sue the insured directly for UM benefits without suing the uninsured tortfeasor. Or two, the insured may obtain written consent to sue and then proceed to sue against the uninsured motorist. And then any judgment rendered on behalf of the insured will be binding on the insurer. And finally, three, the insured may sue the uninsured motorist without consent to the insurer. However, the resulting judgment does not bind the insurer. And if the insurer was to file suit, the issue of damages would have to be relitigated. So this is something interesting to keep in mind, kind of what the insured's options are. But also keep in mind, there's one tactic that I know a lot of us employ. It's called the concept of substitute payment. This is simply where the UIM carrier will substitute its own money for the third-party tortfeasor's liability limits. This allows the UIM carrier to then proceed and bring their own claim against the tortfeasor. This claim can be brought against against the tortfeasor itself and against the liability limits that they may have. So this is kind of an interesting way that you can go after an underinsured tortfeasor that may have some assets that you discovered. But as you can see here, this is quickly where UIM subrogation becomes collection work. Collision and property subrogation, this is a very active area of subrogation and is very important. A couple reasons why I believe it's so important, and I stress the importance of subrogation to many of the people I meet is, one, it keeps the insured happy. I mean, you go after, you successfully recover your third-party subrogated right, and the insured gets his deductible back. I mean, it may not seem like much to you or I, but $500 in the pocket of our insured goes a long way in their eyes, and they're going to recommend to friends, hey, my carrier's great. It also allows carriers to keep premiums low. This is kind of the bigger picture. Money coming back in allows us to reduce reserves and experience modifiers. And like I mentioned, I mean, this is a very active area. Collision and property subrogation makes up, on average, 13% of all paid claims every year. So I'm really staying on top of collision and property subrogation can go a long way in both the eyes of the insured and in big picture, keeping premiums low, reserves and experience modifiers. This is important stuff. Collision and property subrogation is allowed in Texas. It's allowed regardless of whether there's a subrogation clause in the policy, and this is due to Texas recognizing both the equitable and contractual right to subrogation. An equitable right to subrogation is a right as a matter of law as opposed to contractual, which is simply your subrogation rights are outlined in the policy and gives the insurer the right to proceed against a tortfeasor. I've got American General versus Fort Worth as the site showing a right to subrogate in Texas there. An automobile insurer which pays for its insured's property damage has a right of subrogation against the tortfeasor to recover payments. We're stepping into the shoes. We're making a subrogated recovery. When we do step into the shoes and file suit against a liable third party, a defendant, we may elect between two methods of measuring the property loss. We may recover the difference in market value of the property before and after the loss, or we may recover the reasonable cost of repairing the property loss, provided that this repair is economically reasonable. In addition, a person whose vehicle is damaged can also recover the loss of use of the vehicle. We cite Luna versus North Star Dodge. This is the Supreme Court case in Texas, which allows a plaintiff to prove damages for loss of use. And then in order to recover loss of use, a plaintiff only needs to establish the reasonable rental value of a substitute vehicle for the time reasonably required to repair or replace that damaged vehicle. What this means is that there's no need to actually go out and rent a substitute vehicle. It's simply the rental value because you were deprived of that time of using your car. A lot of the time, what I've done to prove up these damages is I go on to Orbitz or any other rental car company, find a similar car and click how many days our insured needed it, and I submit the estimate to the courts. And a lot of time that's enough evidence to show what our loss of use damages are. The Supreme Court in Texas has also held that loss of use can be recovered in instances where the vehicle is a total loss. Now, this is a newer case. I know the last time we presented this webinar that was not the case. So even in instances of a vehicle total loss of use can be recovered. It's something to keep in mind and can be a great way to increase your lien and kind of flex your muscles when a third party is ignoring you because they want you to go away. Another thing about collision and property subrogation is that you have to affirmatively assert your collision and property subrogation rights. This comes up all the time when your insured goes out and gets plaintiff counsel. He's got whiplash, neck injury, and the plaintiff counsel is bringing a bodily injury lawsuit. In that case, your property subrogation claim is not being protected. You have to go in, intervene into that bodily injury lawsuit and affirmatively protect your subrogated right. You have to make, you have to state that you need payments for your interest, for your payments made for this property damage. Otherwise, your rights are not being protected by that plaintiff counsel. All right, as I precluded to the made whole doctrine. Like most states, Texas does have the we like to call it the worst enemy to subro claims. So it does have the made whole doctrine, but there are some quirks here that make Texas a little more favorable than most states that have the made whole doctrine, and I'll be outlining kind of the cases and our logic on how to get around this made whole doctrine. The leading case here in Texas is on the made whole doctrine is Ortiz versus Great Southern Fire and Casualty. In Ortiz, the Texas Supreme Court ruled that the made whole doctrine was applicable in Texas. However, the extent and breadth of that case has for a long time been grossly misunderstood, mainly by plaintiff counsel, and they try to push that misunderstanding on carriers. In 2007, there was a Texas Supreme Court case that had clarified the Ortiz decision and stated that the doctrine and that it made clear that the made whole doctrine in the terms of an insurance policy can negate the application of made whole. In other words, let me restate that. If a contract provides for subrogation, whether or not the insured is first made whole, then the contractual language will control and the equitable defense of made whole doctrine will not apply. This effectively allows us to contract our way out of the made whole doctrine. So if the terms of the insurance policy state that the application of the made whole doctrine does not apply, this 2007 Supreme Court case has allowed us to do so. Ortiz is often, like I said, Ortiz is often cited by plaintiff counsel, and you'll hear it all the time if you do any work property subrogation in Texas. They'll say made whole, Ortiz, it applies. So I think it's important for us to kind of retread the facts of Ortiz and really understand what's going on. So in Ortiz, it was a homeowner. Suffered $15,000 in damages after some carpet was installed negligently and it started on fire. Their $15,000 in damages included $4,000 in damages to real property. This was covered by the insurer, and $11,000 of damage to personal property, which was not insured. So here comes the insurer, and they want to come in and subrogate to their $4,000 that they paid to the insured, but the insured is out $11,000 in uninsured property losses. The insured went ahead and settled with the third party for their limits, $10,000. And of course, the insurer went ahead and asserted its $4,000 subrogation right against that settlement. Now, neither the settlement agreement or any proof submitted to the court indicated which portion of the $10,000 in settlement was supposed to be paid to the insurer. This is the first point we use to distinguish and avoid the application of the made whole doctrine. Texas courts have held that if any portion of the settlement is intended as compensation for damages paid by the insurer is allowed to subrogate after paying a pro rata share of the cost of collection. It's really important to note that the policy in Ortiz didn't have a subrogation clause. This is the point we harp on. We can look back to this 2007 Supreme Court case I keep alluding to, and I'll go into right after this, that states if the policy contains a subrogation clause, we can contract our way out of the application of the made-whole doctrine. Ortiz didn't have a subrogation clause. So that's where the distinguishment gets made when plaintiff counsel come around and toting the made-whole doctrine. Texas has gone ahead and specifically rejected the adoption in Wisconsin in the holding in Garrity. In Garrity, it states that the insurer may not subrogate at all if the insured is not made whole for all of its losses. Instead, we have the Ortiz decision, which ruled that any portion of a settlement is intended as compensation for damages paid by the insurer. The insurer is entitled to subrogate after paying their pro rata share of costs of collection. So in Texas, the party filing suit has the burden of proving that the insured has been made whole, or exactly what portion of that third-party settlement satisfies covered as opposed to the non-covered losses. So just to reiterate, the party filing suit has the burden to prove if what portion of that third-party settlement applies to the insured's subrogated interest. But on the other hand, if the insured settles and when the carrier, us, must file suit to seek reimbursement from the insured, that burden is then placed on us. So I keep mentioning it, that 2007 Texas Supreme Court case, the FORTIS versus CANTU, and MWL actually wrote the amicus brief on this one on behalf of NASP. This case involved a health insurance subrogation case, which the policy did have basic subrogation language. The Supreme Court real simply went ahead and stated, where a valid contract prescribes particular remedies or imposes particular obligations, equity generally must yield unless the contract violates the positive law or offends public policy. So, the golden rule. If a policy has subrogation language, then made whole does not apply. That's the one thing to remember from here. And so I want to congratulate everybody. We made it through made whole. I think it's now a good time to take a little bit of a breather. I want to reel everybody back in by throwing out the trivia question. Like I mentioned earlier, there's a question pane. Make sure to record your answer in that question pane, and towards the end of the seminar, I'll be announcing the winner. Jamie Breen here will be relaying the winner's email and name, and I'll make an announcement. So without further ado, here is the trivia question. Which state is the only state in the U.S. which does not prohibit operating a vehicle while in possession of an open alcoholic beverage, so long as your blood alcohol level remains below 0.08%? To reiterate, to restate, which state is the only U.S. state which does not prohibit operating a vehicle while in possession of an open alcoholic beverage, so long as your blood alcohol level remains below 0.08? Now I'm going to take a sip of water while you guys submit your questions, and we'll move on. All right. Given the time, I know you guys are either Googling or answering the questions, but I'm going to keep moving on here as we're running lower on time. I want to get to your questions. The common fund. The common fund is an equitable doctrine which states that the one who benefits from the creation of a fund should bear a fair share of the costs. This allows the insured and the insured's attorney, the plaintiff counsel, who is likely doing a lot of the heavy lifting on a third-party lawsuit, to recover his proportionate share of costs and attorney's fees. A lot of the time, in Texas, this takes the form of giving plaintiff counsel his 1/3 share. Now, there are some exceptions to this common fund, and these are really big to remember, especially on these smaller files, because remember, Texas is a favorable subrogation state, and what we're trying to do here is prevent the plaintiff counsel from getting his hands on our 1/3 of our lien. We want to recover 100% instead of just 2/3. So if the carrier contributes or assists with recovery, we can argue that we have contributed to the recovery and do not have to give up 1/3 of our lien. This is a fact question that has to be determined by the court, and that's the real great piece of leverage there, the fact question. Because if we can start showing that, hey, we issued some demand letters, we really kind of steered the ship on getting a settlement here, it's a fact question. We have to go to court to determine if you have a right to 1/3 of your cost of collection. Especially on these smaller ones, plaintiff counsel do not want to go through this headache. So it can be a good tool to kind of shoo plaintiff counsel away or try to get them to back down on this stuff. I've got some suggestions here on how to avoid paying out common fund fees. A big one is sending out these notice letters. Send notice to a third-party carrier. Advise, hey, do not settle without involving me, the carrier. Advise that I'm pursuing my own subrogation rights. You can send them copies of medical payments and specials. Ask to send subrogation directly to you, the carrier, even if they don't listen to you. I mean, this is all great material you can document and show to a court that, hey, look, there's a fact question here in terms of how much did we, the carrier, contributed to the settlement. Further, I mean, you can do the same thing to the plaintiff counsel, insured counsel. Advise them, don't settle without me. State that I'm pursuing my own subrogation rights. You know, I don't need your help. I don't want your help. He's not authorized to collect on our behalf, the carrier. All these things, they do wonders in avoiding that common fund question, and more times than not end up allowing us to recover 100% of our subrogation lien instead of just the 2/3 or sometimes less. But if there's also a bit of an ethical consideration that you can kind of throw around. You can state that if plaintiff counsel is going to be protecting your subrogated interest and then later on tries to screw you out of your lien, he can be in some hot water there, as attorneys cannot recover attorney fees from either client if there's a conflict of interest. And Texas law is pretty clear on that. So something to keep up your sleeve if plaintiff counsel starts getting a little shifty or out of line. Release of a tortfeasor by the insured. This is a common situation. Maybe some of you run into it. Your insured runs out and quickly settles for $500. Way to go, bud. Texas law states that if an insured settles with a tortfeasor with knowledge of your subrogated interest, the carrier is still able to subrogate. You can always go against the insured with your reimbursement right that Texas allows. And depending on the terms of the policy, you may be able to bar your insured from any further benefits because he's jeopardized. It's a post-loss jeopardization of the insurer's subrogation rights. So it's always really good practice to put all potential tortfeasors, put your insured on notice as soon as possible of your subro rights. Using regular mail, certified mail, this is all great stuff to document that, hey, you were on notice, you went out and settled with notice of our subrogated rights, and I'm still allowed to subrogate. Accepting partial payments is something I've seen before. A lot of times it's a third-party carrier offers to settle for $4,000 when your lien is $5,000, and you deny. You're kind of, it's a knowing file, it's so small, and hey, pay us our full lien, and next day comes the check for $4,000. Not what you asked for, but there it is. It's in your hand, money in hand, right? How easy would it be just to run to the bank, deposit it, close your file, and be done with the thing? But Texas law states that parties must agree that the amount is paid in full satisfaction. The key here is parties must agree. There must be an unmistakable communication that acceptance is complete satisfaction. It must be clear, full, and explicit. And there's no susceptibility of any other interpretation. Now, of course, I mean, I'm listing, these are all fact questions, but a lot of time checks will come in and they'll say settlement in full. Now, chances are if you endorse, accept, and deposit that check, there's a fact question there if this was an explicit and full understanding that you settled for a partial payment of your lien. But In the scenario that the check does not state settlement in full, if you've made clear to the third party that you want your 5,000, yet you go ahead and deposit this check that does not state settlement in full for 4,000, there is some leeway in Texas, and usually they won't hold that this is in accord and satisfaction in these circumstances. However, you can follow up with them stating another letter saying, you know, hey buddy, pay us another 1,000, or let me know where I can give you service to file suit. Economic loss doctrine, this is another problem we see when subrogating property loss cases. An example I listed here is a Ford F-150 starts on fire and burns up in a driveway. Maybe it's due to a faulty alternator, and you want to look to Ford for recovery under a theory of product liability. The rule, economic loss doctrine, is where a defective product causes damages only to the product itself. Common law does not allow us to recover in tort for purely economic damages. Recover in torts, that's strict liability or negligence. What does that mean? Purely economic damages. Well, it means damage only to the product itself. So the F-150 started on fire because it was faulty, but it only damaged the Ford F-150. There are some exceptions to this. As you see in the bottom right, we've got a lovely home that's currently engulfed in flames. You can sue for other property damage. So if that Ford F-150 is in the garage and the faulty alternator burns down and you've got coverage on that garage, you can go after Ford on a product liability basis. Also, another exception to the economic loss doctrine, any warranty or contract-based statutory remedy you can pursue. So it's always good to look out for these warranties that may exist. One other exception is non-integrated component parts, or if there's any negligent misrepresentation or fraud. The reimbursement of a deductible. This is something that I commonly see be misunderstood. Just because the state has the made-whole doctrine, it doesn't mean you have to refund the insured's deductible. In Texas, it's one of the few states that has a statute, but the statute doesn't actually tell you how much of the deductible needs to be refunded. But it does kind of give guidelines on what you should or have to do. If there's a third party may be liable, you must take action to recover the deductible within 1 year after the claim is paid. So either you have to pay the insured their deductible back, or within 1 year and no later than 90 days before the SOL, you must inform the insured that you have no intent to subrogate and that the insured is authorized to take collection actions to recover his own deductible. To clarify, this statute is only applicable to personal automobile policies. And to kind of explain further, the term takes action just means to take reasonable collection efforts such as mediation, arbitration, litigation. I've seen and demands made to a third party would satisfy take action. But note that the statute doesn't require any specific percentage to reimburse an insured's deductible. In fact, it doesn't really require you to reimburse any of it. But the Texas Department of Insurance has kind of given a recommendation that you should be giving a pro rata reimbursement of an insured's deductible. I guess my advice would just be consistent. However your company chooses to do it, just stick with that. Real quickly, I'll go over the collateral source rule. A collateral source rule is a law that prohibits a defendant from mentioning that the plaintiff has received compensation from some source other than the damages sought against the defendant. Defendant here is just trying to tell the jury, hey, this poor plaintiff has already received money from a different source, such as another insurance policy. However, they're not allowed to mention this because recovery cannot be reduced for an amount that the plaintiff is, because the plaintiff has paid a premium for this insurance policy and should be able to reap the benefits of it. Texas Civil Procedures and Remedies 41.0105 was passed as part of Texas's tort reform back in 2003. This provides an injured plaintiff that is not allowed to recover medical expenses that were originally billed by his healthcare provider, but were ultimately adjusted down by the carrier. What does that mean? It means you can only recover the discounted medical that is being admitted, or you can admit your full medical expenses, but your recovery will be reduced. Collateral sources is one of those kind of technical topics. We've got a ton of sources on our website that cover this and every other topic I've talked about today. I'll go into the website later. Contributory negligence. Texas is in the majority of states, which allows for, it follows the modified comparative fault rule. This means that a plaintiff is allowed to recover damages against a tortfeasor provided that the plaintiff is 50% or less at fault. And a plaintiff's recovery is also reduced by his own percentage of fault. So just some quick math, some examples here. Damages are $10,000, and if the plaintiff is 40% at fault, his damages are reduced by 40%, so plaintiff will recover $6,000. If plaintiff is 60% at fault, it's real simple. His percentage of fault is greater than 50%, and he recovers nothing. The sudden emergency doctrine. This is another area of law that affects automobile subrogation. I see it come up, and a lot of the time it's used inappropriately. The sudden emergency doctrine advises the jurors that if any evidence shows that the conditions beyond the defendant's control were the cause of the accident, or that the conduct of some other person who isn't a part of the litigation caused the accident, then the jury does not have to place blame on any party. The sudden emergency doctrine is applicable if an emergency situation arose suddenly and unexpectedly. The emergency situation was not proximately caused by a negligent act or omission of the defendant. And 3, after an emergency arose, the defendant acted as any reasonable person would have under the same or similar circumstances. And I want to distinguish this from unavoidable accidents. It's a little bit different. We don't see much unavoidable accidents being used today, but it's good to understand both so you don't confuse the two. An unavoidable accident is a situation in which ordinary care and diligence could not have possibly prevented the accident. So unavoidable accidents, think of things such as heart attacks or a sudden loss of consciousness. I mean, no amount of reasonableness could prevent this unless there was other facts. Seatbelt defense, real quick. Texas began mandating the use of seatbelts back in 1985. However, Section 543.413 subsection G is used to state that the use or non-use of a seatbelt was not admissible as evidence in a civil trial. And I state that, but back in 2003, the law was changed by the Texas legislature. It repealed that section, that prohibition on using as evidence, and thereby evidence of seatbelt use or non-use is admissible and can be considered by the jury. That's a good little piece of information to tuck away, because although a lot of time it doesn't speak to negligence or liability of a party, it can be used. The fact that someone didn't use their seatbelt is very frowned upon by juries and can be kind of a tipping point in some smaller files. Bailment. Bailment is the owner of a bailer is the owner of a property. A bailer is someone who holds the property in trust. A bailment is the temporary turning over of custody or control of property to another person for a specific limited purpose. I see we're running out of time, so I'm going to just hit on the highlights here. A negligent bailee cannot discharge his burden of producing evidence and overcome this presumption by merely showing that the vehicle was lost or damaged by a fire or theft. Instead, a negligent bailee has to prove his own lack of negligence. So this can be used to really flip the script on a defendant. They say, hey, I didn't do anything wrong. It was stolen. Well, hey, but like you had complete control of the car. I gave you my keys. This can really, flip the burden of proof and can flip a case. Again, bailment is another example of something we have on our website. You can go more into if you have a specific case with that. Negligent entrustment is valid in Texas. It shows that, to prove a claim of negligent entrustment, a plaintiff must show that the owner entrusted the vehicle to a driver, that the driver was unlicensed or incompetent, that the other driver knew that this driver was unlicensed and incompetent, that the driver was negligent on the occasion in question, and that this negligence approximately caused the accident. I see negligent entrustment get brought up, kind of more of a reason to bring in a creative way to get a bad driver's driving habits or driving records, which are typically inadmissible, but if you bring negligent entrustment, you can bring them in. Guest statute. Guest statutes prohibit a passenger or family member from bringing suit against the driver. Guest statutes are unconstitutional in Texas since 1985, so we do not have one. Family purpose, great tool to use in most states. The vicarious liability rule that holds the owner of an automobile liable for damages to others while a member of the family is driving the vehicle. Unfortunately, Texas does not recognize the family purpose doctrine. You have to prove the independent negligence on part of the owner. Multiple claims in excess. Texas is a first come, first served state, meaning that if there's many large claims, there's nothing stopping a third party from just settling your portion of the case. You can go in there and say, hey, here, look at this case, Texas Farmers versus Soriano, settle with us. There's no duty of good faith or fair dealing requiring pro rata settlements. You can explain, hey, settle with us, close your file, have a good day. Me and you are happy. It doesn't seem fair, but that's the rule here. And then real quick, statute of limitations. There's just a couple highlights here. The ones we'll be dealing with mainly personal injury, wrongful death, property damage. Those are 2 years. You might see a breach of contract is 4 years. And then very rarely you'll have the statute of repose come up on a property damage claim, but SOL on those is 10 years. Kind of flipping through these last couple slides. Like I mentioned, feel free to reach out with me on questions on any of this. I'm happy to field questions. I actually love answering clients and potential clients' questions, as it kind of forms the basis for a lot of the charts and articles we end up doing, so keep them coming. Offer of settlement is a tool I like to use on some of the smaller claims. A plaintiff can make a counteroffer of settlement for a specific sum. This is an instance where you receive a real lowball offer from a third party. If you reject and counteroffer at, let's say, you say, hey, let's settle for 95% of our lien. You can let them know that under section 42.003, if the third party doesn't pay you that specific amount and you end up getting back 100% at trial, you're allowed to obtain 120% of any rejected counteroffers. And you can also recover post-offer litigation costs. So, I mean, this is a great tool to kind of say, hey, settle with me now, or 120% plus post-offer litigation costs. That turns a small claim into quite a large one. However, this must be in writing, this counteroffer, and it has to be served on all parties. So sometimes, especially if the defendant knows the rules, they won't be scared by this, but it's something great to keep up your sleeve, and it has worked in some cases I've had. So that's the end of these substance stuff. I just have wanted to really point out MWL's website here. It's chock filled of charts, articles, anything and everything, especially related to Texas auto. I know I've been spitting out article after article of Texas. Now being down here, I really wanted to highlight this state, but I try to push everyone towards the website. It's a great resource. It's free. We've got all these reference charts here. can see the list of all of our charts and stuff. If you click on that link, we've got so many of these. Total loss thresholds for automobiles, texting while driving, recovery of sales tax after a total loss. Oh man, we got too many. Look at this. I use these charts every day. So yeah, I know we're running low on time. I wanted to announce the trivia winner before I go. The winner of the MWO book of their choice is Deborah Velez at Atlas Financial Holdings. So congratulations to you, Deborah. Jamie will be following up with you with an email asking kind of which book do you prefer. You're really going to enjoy any of the books you choose. Again, I use those every day. I got them in a cabinet right above me. But unfortunately, I'm really sorry, guys. I didn't get to any questions today. I'm 5 minutes over. I promise to keep this to an hour. But send me, here, I've got my email pulled up right there. Send me any questions you guys have about any questions, Texas Auto, Texas Work Comp even. We're here. We love answering questions. I'll get back to you either today or tomorrow. That's what I'll be spending the rest of my time on today. Thanks everybody for tuning in. We had a great turnout. I saw a peak of 310 people attending. So I'm really excited about this. I'm excited about being in Texas and helping everybody subrogate. So that's it for me. Again, any questions, feel free to email. Otherwise, have a nice day. Bye-bye.